Good morning, good afternoon, good evening, depending on your time zone. My name is Miriam Colloon and I'm an associate in the International Arbitration Group of Gibson, Dunn Crutcher in New York. I'm very excited to welcome you today to the first session in a series that we've captioned Reconceptualizing International Law. Our esteemed panel today, joining us from across 3 continents, will be kicking off this discussion by considering the case for reconceptualizing international law and laying a foundation for the series to come. It's been my great honor over the past few months to work closely with my colleague Charlene Yim, counsel in our arbitration team, with Daniel Stewart and Shirin Chua at IILA, and of course with Special Rapporteur Achiume to put together this series. The idea really started when we first read Special Rapporteur Achiume's report, which is going to form the springboard of our discussion today with the panelists. And I think, you know, as many of you can probably empathize as lawyers in the private sector, we often try to maintain a really robust docket of pro bono cases, but sometimes they can be a divide or a disconnect between our billable work on one hand and our pro bono efforts towards issues of inequality on the other hand. And, you know, as has always been the case, but I think has been made stridently clear this year, as lawyers, we play a really important role in shaping and developing structures that influence the way that society operates. And so it's really incumbent upon us to think critically about the way that we're engaging with and utilizing the mechanisms and principles of the international law system, and the way that that's impacting issues of inequality and global justice. So it's our hope that this series can prompt some of these important discussions and develop ideas that can assist us in all becoming more conscious practitioners in our work. And on that note, I'd now like to hand over to Daniel Stewart, the Executive Director of IILA, to provide some more context on this first session and to introduce our panelists.
Thank you, Mariam. Again, welcome to everybody. Please excuse if it looks like I'm calling you from a storage closet. I just moved yesterday. Welcome to session 1. As Mariam said, my name is Daniel Stewart, the founder and executive director of Independent International Legal Advocates, or IILA. And this series is very much within the wheelhouse, the core of our mission, which is fighting the unfairness at the heart of international law, in the terms of who gets to make it, who gets to use it, and how so many voices are left out of that process, and also therefore making international law a less effective, or perhaps even ineffective tool for fighting global injustice. As Mariam said, 2020 has highlighted, if anything, the urgency of this core mission in terms of our sense of interdependence, government as a necessity, not a luxury, the need for long-term planning and strategy, and again, highlighting the inequalities and fairness at the heart of an international system. Now, the audience, you are intended not just to be international lawyers, but those too, practitioners, academics, government, those working to make and shape international law. But as I said, we often talk to each other far too much, and not only trying to persuade my family of the importance of international law, but all of those who aren't lawyers of its central role, again, promise and possibilities to affect global justice. And justice, you'll see that embodied in the series. Often when we talk about global injustice, it's focused, at least with international law, in terms of international criminal law or violations of gross human rights. And they're obviously vital and they will form part of the series. But global injustice in its widest sense, and the series will focus on concrete and tangible changes from international law, from environmental law, investment and trade, to natural resources. And so today's first session will cover many of those different topics, but as Mariam said, really encapsulates thrusting forward and setting out the real case for this, ways to think about these changes. So let me turn now to introduce our incredible panelists for session 1. I know that probably many of these, for many of you, or at least by title, will not need an introduction. Our moderator, host, and also co-organizer, as well as, I say, advisory council member for IILA, along with somebody else, is Professor Tendai I'm going to butcher every single name here. That's intentional, I can say that, just so that they can point out the absurdities of my pronunciation. Tendai Achiume, she's a professor of international law at the UCLA School of Law, and is the current UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. Next up, we have Professor Sundhya Pahuja, coming to us or with us all the way from Melbourne, so you'll appreciate the early hour. She's the director of the Melbourne Law School's Institute for International Law and the Humanities, and the author of a foundational work in this field, the text Decolonizing International Law. If you haven't read it, don't order it as we're speaking, but do as soon as we're finished. Next up, Professor Makane, Moïse Mbengue, Professor of International Law with the Faculty of Law, University of Geneva. Makane has also represented a number of states at every international tribunal, and is also an advisory council member of IILA and a good friend. And finally, for the panel, Professor Balakrishnan Rajagopal is professor at the MIT Department of Urban Studies and Planning, International Law and Development. But tying with Tendai, he's also a UN Special Rapporteur, or the current Special Rapporteur, on adequate housing as a component of the right to an adequate standard of living, and on the right to non-discrimination in this context. We don't always use acronyms. So this is session 1. Tendai will later on introduce session 2 to be held in January. And the idea is every month will be a new topic going through into 2021. We're really excited to have you a part. So over to Tendai.
Okay, thank you so much, Daniel. And thank you everyone for joining us. Thanks so much to my co-panelists. Really thrilled to be able to moderate this conversation. So our goal in organizing this series has been to convene discussants to reflect on the prospects of reconceptualizing international law for decolonial purposes. And I want to begin by highlighting that this is not a new conversation, and arguably it's one that's been a central preoccupation for TWAIL scholars and lawyers. So scholars and lawyers taking a third world approaches to international law lens to the work that they do, including many who are panelists in the series that we're going to be hosting. And some of you, actually, I noticed by looking at the participant list, have also joined us that way. And for those of you who are interested in other conversations along these lines, I want to just start off by pointing you to the recent symposium on the Afronomics Law blog that deals with other dimensions of decolonizing international law. So we're not speaking in a void, but it's definitely a conversation that I think requires as much attention as it can get. And our aim with the series, and even with this first session, is to seek a confrontation between history, theory, and contemporary practice in international law. And there'll be many references to decolonization and to reconceptualization. And when Sundhya speaks, she'll flesh out some of these contexts more. But when we're speaking about decolonization, at least one of the things that we're going to be addressing is thinking about the unfinished business of undoing structures of systemic political, economic, social, and cultural subordination that characterized European imperialism, remain in effect today, and operate through international law as well, and asking questions around what it might mean to remake the international order in more just and equitable terms. So my mandate focuses on racism, xenophobia, and related intolerance. And there are many theories, processes, or axes along which we might understand contemporary injustice and inequality in all spheres of life as they relate to racism and xenophobia and other forms of intolerance. But a lens that centers slavery, colonialism, and their contemporary legacies, that kind of a lens is absolutely vital because of the role that all of these systems have played in producing the economic and political structures and processes that remain influential today. And in my work as Special Rapporteur, one of the priorities I've had is trying to bring to the fore the way the very meaning and operation of race as a structure of contemporary subordination globally can't be divorced from these imperial histories of slavery and colonialism. And so in October 2019, my report to the General Assembly focused on addressing the need for states to recognize their obligations to provide reparations for racial discrimination rooted in slavery and colonialism. And so what I thought I might do, in addition to starting my timer so that I don't speak for too long, what I thought I might do is give some background on the motivation behind the report, explain what the report does, and then tie that back to the central themes of our session before turning it over to our panelists to make their contributions. So by way of background, debates within the United Nations regarding reparations are fraught and stalled, and the geopolitical resistance to reparations from the First World, and by the First World, I just mean nation states that were former colonial powers, the resistance from that universe is immense. But even among UN bodies, UN officials, agencies, and even I would say within the mainstream human rights universe, there's a sense in which demands for reparations that are typically made by movement actors, by some civil society actors and different groups, there's a sense in which those claims for reparations are often treated in a number of different ways that ultimately end up being dismissive. So sometimes they're characterized as overreach. The project of reparations is considered to be impossible, inconceivable, pie in the sky, or else it's trivialized or kind of framed as ill-motivated and being about unwarranted demands for payouts by third world states or third world peoples, when the focus should be on so-called contemporary racial discrimination and other pressing concerns, however they might be framed. And I think the comment I'm about to make will have changed a little bit over the last few months, but certainly at the time when I was drafting the report, there was a sense in which, especially in the nations that owe the greatest reparative duties, the publics in those contexts, were, and I think continue to be, in deep denial, or else don't fully understand what reparations are as a matter of existing law and what they might be in a more transformative sense, and also what role international law, international human rights law has to play, even in the different national contexts where some of these developments might be taking place. And so with this background in mind, I drafted this report, which I don't know, we can circulate it via the link of participants who attended, and you can find it online as well. But I drafted the report because I wanted it to do a number of things, and I'm going to highlight two of them. One was to establish the normative baseline from which reparations for racial discrimination rooted in colonialism and slavery under existing human rights law and existing international law, how that normative baseline should operate based on what we have already. So next year marks the 20th anniversary of the Durban Declaration and Program of Action, which was the outcome of the World Conference Against Racism in Durban that convened people from all over the world to produce a powerful statement and resource on contemporary racism, racial discrimination, xenophobia, and related intolerance. And that statement articulated these issues in structural terms that fully acknowledged how slavery and colonialism remain central to understanding and redressing racial injustice today. And to my mind, the Durban Declaration and Program of Action are among the high watermarks for transnational kind of movement advocacy and knowledge production on some of the ways in which international human rights law might be reconceptualized to attend to the failed or stalled project of decolonization. And so drawing on the Durban Declaration and Program of Action, submissions from a whole host of different actors, and also on interpretations of existing international human rights law and public international law, the report highlights that reparations entails two related projects. One is justice and accountability for historic wrongs, collective and individual wrongs, acts of racial discrimination that are tied to slavery and colonialism. And in addition to this kind of historical remediation project, reparations also entail eradication of persisting structures of racial inequality and discrimination that have resulted from the failure to redress the racism that was rooted in slavery and colonialism. And so the project of reparations is one that is centrally about reforming entire legal, economic, social, and political structures that slavery and colonialism enabled, making reparations, to my mind, a central kind of theme around what decolonization might mean and a central target of what we might be seeking to do when we think about reconceptualizing international law. The report also sought to highlight that reparations exist as an established remedy under prevailing international law and principles. Too often debates about reparations for racial injustice begin from the premise that reparations are inherently exceptional or an unusual remedy, and the report tries to provide examples of where there have been reparations provided, including for racial discrimination rooted in slavery and colonialism, highlighting that one of the features of the way that reparations have worked to date is that they have privileged the groups who have benefited from slavery and colonialism rather than those who've been subordinated. And so what you see essentially is that even the allocation or the kind of pursuit of reparations has been characterized by structural racism as well. And then, and so the report kind of lays out the public international law and the international human rights bases for reparations. In engaging with the doctrines as they exist, I wasn't by any stretch of the imagination motivated by a sense that reparations or racial injustice for colonialism and slavery is achievable within the existing frameworks, and I think it'll be exciting to hear from our panelists about what capacity they think there is within the existing law to think about reconceptualization and decolonization. And I can talk a bit about this in Q&A if people are interested. I'm fairly pessimistic about what can be done with the existing law. I think what part of the problem is the law must be transformed fundamentally. But the aim of engaging with the doctrine was to highlight that even with its fundamental and systemic flaws, the existing frameworks permit much more than has been realized in so many parts of the world. And the kinds of recommendations I make go specifically to kind of reparations, but also speak to how full implementation of the International Convention for the Elimination of Racial Discrimination, for example, would mitigate many contemporary forms of racial injustice in ways that have not been attended to by states, and that would be closer, if not, would maximize the emancipatory potential of the frameworks that we have in ways that we haven't seen. The second aim of the report that I will highlight before turning over to our panelists is that in the report, I explicitly name the reconceptualization of international law as itself a target of reparatory and in some ways decolonial intervention. And again, this is a move that I think many people within the TWAIL tradition have made over and over again, but it's definitely a topic that is rarely discussed within the UN universe. And so UN member states, international lawyers will often point to doctrines in international law like the intertemporal principle and others that they interpret as barriers to legal accountability for slavery and colonialism, and not just legal accountability, but other forms of accountability as well. And oftentimes, pointing to those barriers in the existing law will be used to diffuse any idea of moving forward. And I would say they characterize a lot of liberal hand-wringing around what reparations might be and do, even from sectors that understand themselves to be, at least in principle, on board with the idea of pursuing reparations. And so in the report, I make what I think is an obvious point that international legal doctrine has a longer history of justifying and enabling colonial domination than it does guaranteeing equal rights to all human beings. And so to the extent that we have doctrine in international law right now that perpetuates neo-colonial dynamics, including the failure to eradicate legacies of slavery and colonialism, those laws themselves must be recognized and condemned as neo-colonial and should be subject to decolonial intervention. And so this idea that international law is complicit in the colonial project, itself has to be targeted as a site for kind of both decolonization and also of reparations, is an idea that I hope we will explore through the various sessions that we're going to be having. So just to give you a sense of the structure of the rest of the webinar, I'm going to invite our three panelists to reflect on whether and why there is a need to reconceptualize international law for decolonial purposes, and prompt them to reflect on this question with a focus on their specific areas of expertise in international law. And after they've each responded for about 10 to 12 minutes each, I'll come back with a few follow-up questions and then we can transition to Q&A. So I'm going to mute myself, and Sundhya, I'm going to turn it over to you to start us off.
Okay, can you hear me? I think that's the new way we begin all of our sentences these days. Thank you very much, Tendai, for that introduction and for those very thought-provoking remarks. And thank you to the organisers, Daniel and Mariam, and to the IILA. So I'm very happy to have been asked to participate in this series, and specifically the first one, directed toward making the case, as it were, for reconceptualizing international law, because I think that people of a progressive or liberal disposition, using that word in the American sense, often have a sense of the virtue of international law. And even when they see flaws in the international system, they tend to take what we might call an apply, extend, reform approach. So that is, they try to apply international law to address worldly problems. So how can we use international law to alleviate poverty? They tend to want to extend the operations of international law to make it more inclusive. That is, how can we bring more people into the international legal institutional arena or purview? Or they tend to want to reform international law and institutions, whether to diversify personnel or better to meet international law's self-declared objectives. But for me, reconceptualizing means something different, and it suggests in a way that we need to be wary of these approaches. So reconceptualization invites us to examine the foundations, as it were, to think afresh of the concepts or building blocks in establishing the discipline, and to invite us toward a thoroughgoing rethinking of institutions, doctrines, and norms. But why might we need to do that? So Tendai has alluded to several of the reasons already, but really the central concern would be that it stems from the sense that international law is implicated in producing or patterning those injustices and inequalities that we might be concerned with tackling in the first place. And so for many of us who have this sense, this is because of the history of international law. So Tendai's opening remarks reminded us of the observation that she made in her 2019 report, which bears repetition, which is that international legal doctrine has a longer history of justifying and enabling colonial domination than it does of guaranteeing equal rights to all human beings. This was a very succinct encapsulation of the historical intimacies between what is conventionally understood as international law and the historical period of imperialism. So this is where the relationship between reconceptualization and decolonization becomes clear. But of course, there's a huge amount of research that shows the intimacies between international law and empire. And I'm happy afterwards to share a bibliography if you'd like. That might be a useful thing for people in the audience. But whether it's in terms of resource extraction, racial hierarchization, forced labour practice, or land appropriation, for example, dispossession of Indigenous people, international law was involved not because it was misused in the name of empire, but because it was structured to serve the needs of empire. So for some people, that intimacy is in the past, but for many of us, it continues into the present. And so as well as that historical body of work, there's also a body of scholarship which shows precisely that these imperial structures didn't end with formal decolonisation, and that the relationship between imperialism and international law continues into the present. So this work invites us as jurists and non-jurists to pay attention to the way that the maps repeat, as it were. So if I were, as a teacher, I often use maps when I'm teaching, but if I were to share only one map with you, which I will do now, just one map, you can see that the geography of inequality and the geography of empire are strongly coincidental. But this repetition is not a coincidence, but a pattern. And it's not a natural pattern, but a patterning which arguably international law is involved in repeating. So for jurists in this group, the apply, extend, reform approach is unlikely to make or to produce a more just world and could even make it worse. So for people who see the need to reconceptualize international law, the racist and undemocratic international order that seems to be emerging from the ruins of liberal internationalism is not a betrayal of a post-war compact, but in a sense the playing out of its contradictions and the consistent refusal by its beneficiaries to deal with the legacies of empire. So in essence, we need to reconceptualize international law because international law itself is contributing to the problem, especially because of the repetition or active reinscription of colonial or imperial structures. These can be structures of knowledge or of authority, of doctrine, institutional structures, or crucially, practices of institutional or international administration. And the questions we need to pose to insert a wedge, if you like, into the repetition of these imperial structures, and I think what this whole session and series is trying to get at, is how does international law contribute to the repetition of those structures, and what does that imply for what we should do about it? So this will be politically charged, and I was very struck by the bravery of Tendai's report, and I was interested to hear about the reception of it. But it's politically charged because although the legacies of empire are problematic for most of the world in demographic numbers, they are also highly beneficial to some. And Tendai's report drew this out beautifully with respect to the legacies of slavery. Beautifully is probably not the right word. I mean that in a scholarly sense, but very effectively, I should say. But that differential legacy, if you like, is what makes the project of reconceptualization or decolonization not simply a task of intellectual revelation or incremental institutional reform, but a political battlefield. This is not a smooth world of technocratic instrumentalism. So this can also be professionally very uncomfortable if your orientation lies in that direction, because not every institution or doctrinal formation can be reconceptualized or decolonized. And if we think that it can, we risk cheapening the concept of decolonizing. I can come back to that, but I saw someone writing about decolonizing the Bretton Woods institutions, which I have to say I was very skeptical of, because some institutions may need to be dismantled in order to contribute to the project. And specifically, I think identity-based approaches, which might change the nationality or colour of the personnel, but maintain the same structures, don't tend to contribute to substantive redress and instead tend to produce what I call an assimilated diversity, which we need to avoid. So just in conclusion, I suppose one example of all of this is drawn from my own work. Is the idea of development. So we tend to understand the objective of development as a project of international or national law, and we tend to understand the concept as a proxy for human progress and well-being. But even a brief historical study of development and its invention in the 1940s reveals that development is a concept which picked up where the civilizing mission left off. And so when we come to the question of how we must think about reconceptualizing and decolonizing, I'll make the point that historicization is a crucial element of this, because it's through the attention to the historical invention of such concepts that we can be attentive to their effect. But development, in a sense, reproduces the civilizing mission because it perceives difference. So it perceives difference, and like the civilizing mission, rearranges it in a hierarchy by locating some people and some ways of life in the past and some people and some ways of life in the future through a fictitious story or projection of a universally shared history. So in other words, we describe some ways of life as traditional and dying out and others as modern, whereas actually they are all coexistent but different. And like the civilizing mission, development generates a moral imperative to assist the underdeveloped to become more like the developed, also according moral authority to the powerful. So that hierarchy, the crucial thing, I think, for where it intersects with Tendai's brief is that that hierarchy reproduces the racialized hierarchies of colonialism, but conceals the racialized basis of it by attributing the differences to culture and particularly to economic culture. So as Frantz Fanon once put it, once biological racism was discredited, cultural racism, or the defense of Western values, did its work. And the effect of the reproduction of this hierarchy is to produce a geography of knowledge in which knowledge is only ever understood as properly coming from the north to be applied in the south. And that geography of knowledge results crucially for us as lawyers in a distribution of authority and moral authority upwards into the international or northwards into the global north, and a distribution of responsibility downwards into the nation state. And by doing that, by making that, affecting that distribution, it secures regimes of exploitation, including things like investor-state dispute settlement, which may be controversial in this audience, but by re-narrating them as necessary for the poor in the name of development. And their development is equated with a kind of undifferentiated notion of economic growth, even though the effect of those doctrines and institutions is both to enrich the wealthy and reduce democracy in the South. So just as a closing provocation, in Tendai's report, she noted that Germany, for example, has acknowledged that it has a moral and historical responsibility to Namibia, which is good, but has conducted quote unquote targeted development projects as part of its reparation. And one of the things I would urge us to think about is, or I would strongly argue that any move towards reparations directed through the development machinery or development aid are the wrong kind of reparations, and I would be wary of them. So I would urge us to think about justice-based claims rather than development-based claims. So in Canada, for example, the residential schools, the question of how to compensate for the stealing Indigenous children and launching a project of assimilation has been dealt with in a very different way, and arguably a better justice-oriented way that recognises the strength and existence of First Nations laws, whereas in Australia, because of our current political configuration and historically, the tendency has always been to think about reconciliation in terms of closing the gap. But the closing the gap between Indigenous and non-Indigenous reproduces an assimilationist doctrine. So reparations, in my view, shouldn't take the form of development in any shape or form. But there are obviously many more things one could say about this, but I'll stop there for now and hand over to my fellow panelists.
Thanks so much, Sundhya, and I'm going to turn it over now to Makane.
Thank you very much, Tendai. Good morning to all, good afternoon, and good evening. It's a pleasure for me to intervene in this first series of on reconceptualizing international law. I would like, of course, to thank very much the organizers for the invitation. And Tendai, I would like to congratulate you for this fantastic report. that you have you have produced. So I have chosen to talk about the investment regime, mostly because I have personal experience in negotiating investment agreements in Africa, and also in being involved in investment arbitration. So Tenda, you were asking us to actually think about whether or why it would be important to reconceptualize international law for decolonial purposes. Let me just share with all the participants here and the panel just an anecdote, something that I have witnessed recently. So I have been appointed recently by a French-speaking country in Africa to represent it in some investment arbitration proceedings before the ICSID, the International Center for the Settlement of Investment Disputes. And one of the lawyers who is working with me is Anglophone. So we have decided that we would submit all our written submissions in both English and French. But then the lawyers from the other side, so the lawyers representing the claimants, which are lawyers that are based in Europe, wrote to the tribunal to complain that actually that country is making submissions in both English and French, and that country, because it used to be a former French colony, should limit itself in presenting its arguments in French and no other language. So the position of those lawyers is that, you know, a sovereign nation, even today in 2020, doesn't have the right to choose the language in which it would like to present its arguments before an international tribunal, even if the rules that are governing that international tribunal actually allow, you know, for diversity of languages. So I could stop here just, you know, to respond to your question with this anecdote to say, yes, definitely there is a need to reconceptualize international law for decolonial purposes. This is not just a theoretical debate. It is a practical debate that anybody who's involved in the practice of international law today is actually witnessing. But allow me just to say that the idea of decolonizing international investment law in particular is not that new, by the way. I'm sure that here many colleagues would maybe remember that already in the mid-19th century in Latin America, there was a very famous doctrine that was formulated, the famous Calvo doctrine. And the old Calvo doctrine was basically, you know, a rejection of some sort of so-called customary international law that would protect foreign property situated on the territory of states. So the basic assumption behind the Calvo doctrine was that, you know, by contrast to what some powerful nations were claiming already in the 18th century, international law is not the body of law that should govern the protection of foreign property that is based on the territory of states. So I would say that this is not a new debate. But then, if you also look at the big wave of independence in the 1960s, there was a real struggle, a real battle for the decolonization of investment law. If we think, for instance, about Resolution 1803 of 1962 of the UN General Assembly, entitled Permanent Sovereignty over Natural Resources, Resolution 1803 to a great extent was a rejection of some of the investment standards that have been formulated by powerful nations. For instance, it was rejecting the famous Hull formula, which was pretending that in case of compensation, you know, nations have to pay prompt, adequate, and effective compensation. Resolution 1803 rejected the Hull formula. another very important resolution that was actually adopted during that era, that was an era for the battle for the new international economic order. It was called the battle for the new international economic order, was Resolution 3281 of 1974, the famous Charter on Economic Rights and Duties of States. The Charter on Economic Rights and Duties of States was also another instance of, decolonization, or at least resistance, against the international law, the international investment law that was formulated by more powerful nations at that time. So there has been decolonial strategies that have been put in place already for a long time when it comes to the investment regime. And when I think about these resolutions that I've just mentioned, it's very interesting that actually they were really perceived, even in the practical world of international law, as strategies of decolonization. Because there was a dispute at the end of the 1970s, if I remember well, 1977, you had an award that was rendered in a case between Texaco and Libya. And Texaco versus Libya was actually decided by a sole French arbitrator, at that time, Professor René-Jean Dupuy, who actually later on became the Secretary General of the Hague Academy of International Law. And if you read the award of René-Jean Dupuy in the Texaco versus Libya case, you will see that actually he has interpreted those resolutions, Resolution 1803, Resolution 3281, as elements of resistance against the powerful nations. In many parts of that award, René-Jean Dupuy is, for instance, describing those resolutions as ideological strategy for development. He used the expression, these resolutions are reflecting ideological strategies for development. He also decided not to give an important legal weight to those resolutions, saying that they were opposed, that rich nations which are in charge of international economic relations, he's saying that in the award, that rich nations, that developed nations that are in charge of international economic relations voted against those resolutions. So it's very interesting to see that actually some of these big practitioners, big names of international law at that time, saw these moments, those instances as decolonial strategies that powerful nations would have to resist on. But the point on which I would like to finish now, which I think is very interesting for us to think about, is to wonder why these attempts for decolonization of the investment regime did not actually work out. Why did they fail? Because we've been having these great resolutions, but it was just victories on paper. And the question we need to ask ourselves is why? And when it comes to the investment regime, but I think it's also applicable in other fields of international law, I believe that there are three factors that have led to the failure of those decolonization strategies. Three factors. First one, what I would call dependency. Second factor, competition. Third factor, conditionality. The dependency. Well, what we have realized is that many of these countries, they could not effectively proceed to decolonization because many of them are very dependent on foreign direct investment. So this dependency, development being very dependent on, more developed nations, more powerful nations, has actually limited, the decolonial purpose. And I think this can be applicable in other fields. Competition. Many of these countries were not able to effectively put in place this decolonial purpose or this decolonial discourse, because these countries in the economic field, in the investment field, are in competition. I remember one day I was in a country in Africa where I was telling a minister of foreign affairs why he should not sign a bilateral investment treaty with Canada. And he told me, well, we have to sign it because the neighbors have signed it. already a bilateral investment treaty with Canada. And if we do not proceed, the neighbors will get all the foreign investment, and we won't. So you cannot have an effective strategy of decolonization if there is no solidarity between developing nations. Competition is a hurdle. And then last but not least, conditionality. The external forces, Sundhya was referring to it at the end of her presentation, mentioning, for instance, the IMF. External forces are very present when it comes to the international economic regime, when it comes to the investment regime. You have external forces that are putting pressures, that are conditioning aid, or, how do you call that, financial credit and so on, that are conditioning it to adherence to the dominant investment regime that has been put in place by the rich nations. When you think about, programs like doing business, you have a lot of developing countries that want to have their name being put at the top of the list of doing business. Doing business is World Bank connected. And, one of the elements of the doing business, if you want to be a good country in the doing business list, you have to show that you've been concluding bilateral investment treaties or investment agreements, but adhering to the models coming from the developed states. So I think that any reflection, any thinking on why and whether we need to reconceptualize international law for decolonial purposes needs to take into account these structural barriers, structural hurdles that are here. And when it comes to the investment regime, we've been witnessing those hurdles, and this is what has explained till now the weaknesses and the failures in really putting into place a decolonial strategy. So I will stop here and continue during the discussion. Thank you.
Thank you so much, Makane. I'm going to turn it over to Raj now.
Yes, thank you, Tendai. Once again, let me also join others in congratulating you on your wonderful report. And also, I thank the organizers as well, UCLA and IILA, for inviting me to join this wonderful panel. I found the report very refreshing and a much needed intervention. As you point out in your report, international law has continued to be a barrier. And you start with the new attempt to reconfigure international law by anchoring it in the Durban conference, which I think is very appropriate. You draw attention to the two phases of international law, as you said in your opening remarks when discussing the question of reparations, that it must deal not only with the past and the consequences of the injustices of the past, but that it must deal with the continuing problems of the present, the current injustices, both of which are connected. This has been a central theme in TWAIL literature, as you know quite well. And so I was really gratified to see that. You also, of course, keep your eyes open in your report and point to the real barriers that exist in legal terms. For example, the continuing problem posed by the intertemporality principle when dealing with questions of reparations. But you don't end there, but you kind of end on a hopeful note by drawing attention to some of the more recent impressive gains that have been made in the struggle for reparations, including the Mau Mau lawsuit, as well as the AFRICOM settlement and so on. So on the whole, I thought it was a wonderful intervention, and I was gratified to say that anchoring it in the Durban conference was actually highly appropriate. As someone who is coming from or who's going to comment on human rights, I found that it was an appropriate kind of a bookmark, if you were to call it that way, in the sense that I would say that the Durban Conference was probably a moment when a new generation of TWAIL was coming of age. The earlier demands for a more equal international law between developed and developing states that should take account of its colonial past, which had been leveled by earlier jurists such as Mohammed Berjawi and others, had kind of concluded, and the solidarity shown by many of the developing countries in the immediate post-Cold War period, immediate post World War II period, had dissipated, in the 60s and 70s. And what we were witnessing was the rise of a new form of the third world, a third world consisting of ordinary people who are organizing in more and more innovative ways in the form of social movements and other collectivities that were able to increasingly have an impact on the international level. And we saw that in Durban. The United States, for example, the African American community in the United States participated as a whole for the first time in an international conference in Durban. They had never participated together like that in any conference before. There were substantial mobilizations by other communities advocating the rights of Palestinians, the Dalit community from India, whose action left a profound impact on the conference, but did not find a mention in the end in the final outcome document, as you know quite well. But there were other groups, the Roma and the Sinti communities, migrants, people of African Asian descent, the Burakumin in Japan. The number of groups that were able to gather together under an umbrella was unprecedented. And to me, and I think to many of the activists and movements that participated in Durban, that was really the most important gain. Not so much whether laws were changed and whether international law was dramatically transformed and so on, which continues to be, of course, a major issue, but the very fact of coming together and affirming their solidarity and showing that a new form of solidarity is possible beyond the solidarity expressed by developing countries in the form of a state-to-state solidarity for that brief moment when resolutions on the new international economic order or permanent sovereignty or natural resources were possible. But that was a different moment. But this was a different moment. And we saw the emergence of a new third world in over several years. But I think Durban was an important moment when that happened. I want to say that the idea that the history of human rights is Eurocentric is not a new criticism of human rights and has been leveled by many scholars. But I think we also need to clearly recognize that while it was Eurocentric, human rights framework has been sought to be transformed on the inside by a continuous process of contestation and engagement by the third world. Initially, the developing countries that joined the UN Human Rights Commission in the 1960s and whose membership in the commission led to a dramatic change in the agenda of the commission, for example, inserting rights such as racial discrimination and right to self-determination for the first time, which the so-called previous defenders of human rights, which are mostly Western countries, had not managed to do so until the mid-60s. It was the expansion of the commission in 1967, in particular, because of the newly independent states that led to the transformation of the agenda of the commission. And then subsequently, the expansion of the commission's membership in 1979 in the form of more members who had become independent led to a completely innovative procedure in the form of individual complaints mechanisms, which was actually the foundation for the special procedure mechanisms that you and I are now holding. Argentina was the first test case, but a lot of the mobilization really came out of work that was happening in developing countries. And I think we have to really give this credit really to the critical formative role played by developing countries. In other words, contrary to the common popular myth that the Western countries are the ones who are champions of human rights and developing countries are usually enemies of human rights, or they have to be dragged kicking and screaming along. The reality is a little bit more complicated. And I think we can draw a straight line from the right to self-determination inserted into the covenants in the 60s to the new international economic order and the permanent sovereignty resolutions, the resolution on colonial countries and peoples that you cite in your report, to the resolution on Declaration of Right to Development, which did seek in its own modest but complicated way to reconfigure the meaning of development, precisely to take on board the sort of criticisms that Sundhya and myself and many others have actually leveled. And you can draw a straight line from those declarations to newer declarations like the Declaration on the Rights of Indigenous People, with all their shortfalls, but they are still connected, tethered to each other, I would say. So if so far I've spoken like I see this as mainly a positive sort of story when it comes to human rights. Let me just disappoint that, or say that, well, I'm not going to let people down if they are more used to me pointing out the negative side of human rights, which is usually the case. I mean, colonial legacy, of course, lingers heavily. The whiff it's a heavy stench. It's with us all the time. And we can say many things about it, but I would just mention three things in terms of colonial legacy. One is just the very language and the epistemology of rights, the very sort of material and moral possibilities within which the idea of rights is sought to be realized. For example, the idea of standard of living, which is very much sort of positioned within the epistemology of development. Going beyond rights to sort of taking into account other forms of resistance is therefore a crucial part of coming up with a way to kind of decolonize rights. But I would say, as I have argued in my past work, we have to ask not whether we can decolonize rights, but whether we can decolonize resistance. And rights may be one of the strategies in doing that, but not the only strategy. A second sort of legacy, colonial legacy that lingers with us, of course, is a racial identity of rights talk. And here it's not so much the sort of expertise that one is expected to have when you are assumed to be speaking for on behalf of rights, but also the institutions, the physical locality of institutions based as they are in the global north, almost no one in the global south, for example. The particular practices that are valorized and celebrated as being best practices, for example, with very little attention paid to, for example, practices from the South that may be legitimately be seen as pioneers in advancing the sort of the arc of human rights. I think we need to reverse this directional flow and ask what South has done in terms of its impact on practices and institutions in the North, for which there is increasingly emerging evidence. The third, the last sort of thing I would say about the colonial legacy of human rights is, of course, pointed in your report in terms of the barriers of public international law, in which human rights law is, of course, very much trapped, in the sense that it results from the actions of states. Its basic sort of legitimation comes from the fact that it is rooted in a process of law making by formally equal states that provides a source of legitimacy for mechanisms such as ours, special procedure mechanisms to engage with different countries. But having said that, as you point out in your report, there are a number of legacy problems, issues such as temporality, intertemporality, but also other doctrines such as sovereign immunity that have prevented the legitimate demands of many communities to in the debate for reparations, for example. We also have other problems that we can see in the area of the barriers of international law, and that has to do with, for example, the matter of dispute resolution, where many of the former colonial countries have conveniently excused themselves from the compulsory jurisdiction of, for example, the ICJ, UK's, United Kingdom's, compulsory jurisdiction, exempted, for example, any fact or situation that existed before 1969, thereby exempting itself from any demand from formerly colonial countries. France withdrew from the compulsory jurisdiction of the ICJ and so on. I mean, so there are, with the exception of extremely few occasions, the formal legal bodies under international law, including the ICJ, have really not had a chance to really deal with the sort of issues that you're raising in your report, and that is really an unfortunate barrier of international law. Finally, I would say that the barriers that we have, our colonial legacy that we have, goes beyond international law to the colonial legacy of the inherited laws within countries, as countries have actually, transitioned from colonial rule to, post-colonial situations. Most of these countries have retained their formal laws, and this has proved to be an enormously influential source of the continuation of colonial practices and extractive mechanisms that are being now carried out in the name of a global capitalist elite. So I believe I may have spoken enough at this stage. So let me stop, and maybe I can say more during question and answer. Thank you.
Thank you so much, Raj, and thanks also, Sundhya and Makane. You've just provided so much rich content, and there's so many things that I might ask. And I'm going to start by proving how ungovernable I am by deviating from the questions I told you I was going to ask initially, and tailoring actually the first question I have, offering you the opportunity to respond to different questions based on your presentations. And then before I pose those questions, though, I do want to let all participants know that the Q&A function is available. And I'd like you to ask whatever questions that you might have so that I can begin to integrate them into my questions with the panelists. So please do jump in if you're in the audience with questions that you might have. So I'll start with you, Sundhya, and I really appreciated the way that you phrased the nature of the work that is required. So you said it's not about intellectual revelation, it's not about technocratic reform. When we're thinking about reconceptualizing international law for decolonial purposes, it's a profoundly political project. And from some of the ways in which you were articulating what that might entail, I was also kind of hearing an abolitionist, kind of push there, which is that for some institutions, for some bodies of law, there is no reforming. It is about getting rid of them and starting from the ground up. And then another thread of your analysis, I think, made another important point, which is that some of what you might think of as liberal crisis, I think, that characterizes the international system right now, that sometimes frames, what we're experiencing as aberrational, you've recharacterized as a kind of coming home to roost of what the regimes that we have, the contradictions of the regimes that we have, rather than something kind of aberrational. I want to ask whether you see this as generating an opportunity for a more explicitly abolitionist thread within international legal scholarship. And that's a separate question from another one, which I'm curious to hear you speak on, which is whether ultimately the project for international lawyers is the abolition of international law. That's a provocative question, but I ask it actually genuinely, and would love to hear your thoughts on whether that's what, for those who are international legal scholars, that's where we should be orienting our energy. And then for Makane, thank you so much for your contribution and your, as you described your anecdote, I didn't know which way it was going to go, but it was a truly stunning kind of anecdote that speaks to the nature and variation of the challenges. You speak about dependency, competition, and conditionality as structural barriers that have prevented coming to fruition of the decolonial work that different sectors within the global formation have pushed for decolonialism. I'm wondering, is there any hope? And I want to ask you a question that I think might be on the minds of some of the international legal practitioners that we have on this call, which is that given that structural account of the barriers to decolonization, is it conceivable that international practitioners could identify kind of decolonial legal practices, right? And you might think about this in the context of international investment law. Or is it basically the kind of thing that means that any kind of change would require the obliteration of the existing universe that we have and the recreation of another one that would get over the barriers that you articulated? So really pushing you to think concretely, or at least think with us concretely about whether there can be decolonial legal practices in the contemporary moment that international investment lawyers might reflect on. And then Raj, thank you also for your intervention. And one of my greatest regrets is that I was not of sufficient, whatever you want to call it, to be at the Durban World Conference Against Racism. And actually offline, I think you and I should talk about really important work that we might do to bring together knowledge about the movement work that was done at Durban. But I thought that among the many different things that you said that were really inspiring, I think what your call to think about decolonizing the resistance as a priority, I think, is a really important one. And I'm really curious to know what this might look like in the context of your mandate. So you've just taken on this mandate in the context of right to housing. I'm really excited for the work that you're going to go and do in that universe. But I'm wondering whether you might speak concretely about what decolonizing resistance might look like in the context of your agenda going forward. So I'll turn it over to Sundhya to start in responding, and then we'll also encourage people to populate the Q&A with their questions.
Thanks, Tendai. And thanks, Raj and Makane, for your amazingly thought-provoking conversations. Raj, you've long been an inspiration of mine in particular, so I probably should have prefaced everything I said with, everything I'm going to say anyway. So it's a pleasure to be on the same panel. So Tendai, your question about abolition is extremely useful, and it's a very astute encapsulation, I think, because if we use, for example, if we return to Makane's observation that this is not the first time non-white international lawyers have spoken about the colonial inheritance of international law. The entire post-war history of international law is full of efforts by leaders in the global south and resistance leaders, not just national leaders, but other kinds of leaders in the global south, precisely to push back against the imperial inheritance that they knew was international law. They were not fools. It's not like you had to discover theory to understand that international law was a continuation of empire. And when we try to understand why they failed, we need to take a historical approach, because they did not fail for natural or primordial reasons. They failed because they were killed. So it's very different to saying there's a body on the floor that's dead from natural causes compared with there's a murder with a dripping knife in the room. And you can read books like Adom Getachu's book, World Making After Empire, or Jessica White's book about human rights and neoliberalism, or many other books, Tony Youngi's work, B.S. Chimney's work, to see that those initiatives emanating from the global south in the period of decolonisation were explicitly fought against. So it's a political battlefield, as you say. They didn't just die because they were doomed to failure. So why they failed is a very, very important question for anyone who purports to be interested in this kind of thing, to go back and read that stuff. So then the question of reformation or abolition is a good one, because, for example, if you take the international investment regime, it relies on a series of assumptions that at every point have been subjected to institutional and ideological contestation. So first, it relies on an assumption that without an investment treaty according rights to investors, there will be no foreign investment. That's step one. Then the assumption under that is foreign investment is good for development in a blanket way. That's step number two, which was itself a subject of international ideological warfare. And then the third thing is, well, why do investors need special rights, right? That's the justification. So if you take a reformist approach, you might say, this regime is secret, it's not fair, we need to have an investment court, a permanent court of international investment, we need to proceduralize. But arguably, the proceduralization of something like that is a very good example of when we need to fight for abolition. Because actually there's no justification for the according of extra rights to investors. And you have to say, well, if there's no empirical justification, let us understand historically how those rights came to be protected. Once we understand that, we can understand whether we think reform or abolition is the appropriate path. And the same can be said of the establishment of the Bretton Woods institutions, about which I've written quite a lot, the Bank, World Bank and the Fund. So people must make up their own minds about whether taking up the instruments that are available and trying to reform them is better than actually trying to say those institutions were conceived, designed and built with an imperial purpose at their heart. And now we have to think about whether getting rid of them is better than trying to reform them. So I think those are difficult questions, because people need jobs and people go to law school and we all get absorbed into a story of the marginal but virtuous idea of international law. So they're not questions which don't affect us, our lives and our livelihood either. But as a political question, I think we need to keep the question of unreformability on the table. I suppose the question of the abolition of international law would be one that I would push strongly against, actually, surprisingly, but I would have a particular kind of response to that, which is to say the international law we have today that we call international law is not the only international law. And so I don't think that it's useful to pretend that there can be a world without law, but I think that we need to be attentive to the plurality of law and legal sources and say this system of international law is not the only one. It squashed out a whole lot of others. And part of what we need to do is think harder about how we encounter rival regimes. So Raja's point is very well made about the idea that the nation state and the laws of the nation state were themselves empire writ small to enable the localization of rule over practices of extraction, for example, or property rights, which themselves pushed off the table First Nations law or Indigenous law or other forms of legal system. So I think if we want to reconceptualize international law and hold it to a project of justice, we need to rethink of it as a law of encounter and be not so sure that there aren't other international laws that we need to pay attention to and think about how we encounter them rather than how we squash them. And the question for me is always, well, who decides in this institution or this doctrine or this norm or this practice that I'm looking at? Who decides? And that, I think, is a very useful first step to telling you whether it needs to be reform or revolution.
Thanks so much, Sundhya. And just in addition to the powerful recommendations you made for reading, I think along the lines of the arguments that you're making about having a broader sense of what international law might look like, Natsu Taylor Saito's new book on racial justice as a decolonial project, I think does really powerful work to gesture in that direction. And James Gathi's keynote, The Promise of International Law, a View from the Third World, I think is also, in terms of people who are looking for reading, I think both of those.
There's a great list. I mean, we could compile a bibliography if people wished and share it, because there's really some very great text I haven't even mentioned. The list is quite long.
Yeah, that we will definitely take you up on circulating that list. Makane, can I turn it over to you?
Yes. Thank you, Tendai. Just if you allow me, just to jump back. Yes, if you allow me, just to jump back on your very important question to Sundhya, also on whether the decolonial project is of an abolitionist nature. I think I also agree with her, at least when it comes to investment law, the investment regime, that I don't think that developing countries are actually trying to abolish international investment law, but there is one strategy that we see, for instance, in Africa, which is what I would call the domestication of international investment law. You have countries like South Africa, for instance, that has decided no longer to conclude investment agreements, bilateral investment treaties. And what South Africa has decided to do instead is to adopt, since 2015, a South African investment law that is actually, integrating investment law, but in a domestic law instrument. And Tanzania has done the same. In 2017, Tanzania has adopted a new law called, law on permanent sovereignty over natural resources, where Tanzania was actually excluding now the possibility for foreign tribunals, meaning international arbitral tribunals, to decide disputes regarding, exploitation of natural resources in Tanzania. So you have strategies that smells like abolition, but they are not. But they allow developing countries to reclaim a certain jurisdiction on how they want to implement, to interpret, and to apply standards of international investment law. But then you were asking me how legal practitioners feel about, decolonial practices. My experience, if I take my experience in Africa, for instance, my experience with negotiators of investment agreements in Africa, if you use the word decolonization with them, they get scared. They get scared. If you come on the table and you talk to those practitioners and you tell them about, okay, what we are doing now is some sort of decolonization, most of them get scared about the word. So what I have found out is that you need to think about labels, about other labels that are actually, reflecting a decolonial project, some decolonial purposes, but without calling them like that. So for instance, in Africa, we've been a lot talking about, Africanization, Africanization of international investment law. This is something that has become very trendy. The idea that Africa is, giving its voice to the making of international investment law. So de facto, it is some sort of decolonial practice, but we don't call it decolonization. We call it the Africanization. Africa owning its approach to investment law. But yes, we have some decolonial practices on the table, and I would say two of them that you can see, for instance, again in African new generation of African investment instruments, is the rejection of certain standards. So you don't reject the entire investment law, but you reject those standards that are simply not adapted to development concerns. Fair and equitable treatment, I think I don't need to explain here in this thing here. But FET, what is FET? What is the relevance or usefulness of FET, or fair and equitable treatment, to developing countries? Nothing. So we've been seeing recently in some African investment instruments, if you take, for instance, the Pan-African Investment Code, rejection. There's no mention at all to FET. So you need to be selective about the standards that are useful for achieving development. Then it's not only rejecting. Another decolonial practice we have developed in many of the investment agreements in Africa is that what I would call the tailoring of certain rules, tailoring of rules that would allow, for instance, developing countries, in particular African countries, to be able to achieve development concerns. So for instance, how do you want in Africa, and this is I'm joining here what Raj was saying, but how do you want in Africa to really promote development if you don't promote responsible investment? If you don't promote investment of quality, how do you really achieve development in those countries? So the dominant model of investment agreements coming from rich capital exporting countries has been just a model of protection. You just protect the foreign investor and you don't care about, those countries achieving their development needs. But so you need to think about tailoring rules in order to achieve those development concerns. So for instance, why not inserting investors' obligation? We've been inserting investors' obligations in investment agreements in Africa. Investors' obligation dealing with corruption, because corruption is a big problem for us. It's maybe not a problem for the US, but it's a big problem for us. Socio-politic obligations, preventing investors to engage in coup d'etat. It's a big problem in Africa. So you need to think about that type of obligation. Obligations, preventing land grabbing, for instance, in Africa, it's very important. We have the problem of land grabbing by foreign investors. So decolonial practice for me is about tailoring international law, and it's about rejecting certain of the standards. And this is what we've been doing. But I insist to say that in many contexts, the word decolonization scares some of these practitioners. So you need to think about other ways of presenting it.
Thanks so much, Makane. And I can't resist but say corruption and even coup d'etats are definitely a problem in the United States as well. So
I was provoking you. I wanted you to say that.
Okay, I rose to the bait.
I didn't want to say it.
Thank you so much for that. And when we were organizing this, one of the calls that we had in the back of our minds is, oftentimes you hear from practitioners saying, what might this look like concretely in practice? And I think you've done a really helpful job of naming some concrete interventions. Raj, could I turn over to you?
Yeah, sure, thanks. I just also cannot resist but say something about abolition. I mean, there is no question that some institutions don't deserve to be there. They are beyond redemption, for example. But, we've had a history in international law of some institutions and some doctrines being abandoned in the past, or being abolished. I mean, Center for Transnational Corporations was abolished, for example, in the early 90s, thanks to pressure from the US. But the outcome was that it produced something far worse. So if you are actually criticizing the Center for Transnational Corporations or the UN as being an ineffectual, a complete whitewash of an organization that was put in place simply for symbolic reasons that did not have any impact on what corporations are doing. Well, the bad news was that it was succeeded by far worse. It was succeeded by nothing. And it was succeeded by basically a celebratory neoliberalism during the 90s, in which it was hard to find sites where transnational corporations could be criticized. With all the mellow criticism of the work that was coming out of the Center for Transnational Corporation by the standards of say a hard left critique, it was still pretty much what we had in international law. And the point I'm trying to make here is that I think that calling for abolition, if it means abolition of this institution or that doctrine, to me is not really an argument for abolition. It's an argument still for reform. It's a reform pushed by one set of actors over another. And we just have to remember that every act of abolition will also be an act of creation, because in the end, it'll end up creating something else. And we just have to be sure that what we are actually creating is actually better than what we are abolishing. For example, in all the debate about the World Bank, I've often heard people talk about the competitor agencies now being established through BRICS. For example, the BRICS Development Bank and so on. Is that really a better mechanism? Well, the jury's out there. And one day, I think we'll all make up our minds about whether World Bank was, on the whole, not so bad after all. After all, they have, for example, an information policy which compels them to share information about things, whereas the Asian Development Bank has no such thing today. They might have it next year, but as of today, they don't. I mean, so it's a question of what you compare and what you think you'll end up with if you go for abolition. So that's sort of a broad thing I wanted to say. And in terms of what you said in Tendai about the Durban conference, you're absolutely right, and I'd love to do more with you on this going forward. I mean, the year after the Durban conference, the first conference I organized at MIT was a conference on reparations, and I published a small edited volume out of that. And many of the usual TWAIL suspects were there in it, including Tony Angi and James Gadi and so on. And many of the activists who are actually involved in the movement in Durban, for example, Joya Ayetoro representing NCOBRA, or Kathy Sridhar representing the Dalit rights movement and so on. So I think that Durban is underestimated and overlooked globally politically because of the unfortunate fact that, it concluded on 10th of, September. And then we had 9/11 happen on the next day. And then the news cycle was completely taken over by 9/11 coverage, and it disappeared, it fell out of sight. And that's really unfortunate. And then any follow-up events, after 9/11 were totally poisoned by the counterterrorism attitude, the framing that was pushed and the attitude that was actually put in place by the Bush administration in the early 2000s. So for example, you couldn't even get the third committee to actually approve the outcome document. The fifth committee did not approve the budget in the General Assembly for the anti-discrimination unit, which the High Commissioner wanted to create within the OHCHR. So this is unfortunate reality of what happened to the Durban conference. And I do think that it needs more attention and study from international lawyers going forward. In terms of how do you decolonize resistance, well, that's, a very long conversation, but at least, maybe I can take that part about decolonizing resistance by looking at decolonial legal practices, particularly as they relate to maybe my mandate a little bit, but more broadly as well. But I think that broadly we can see that, the kind of movements that used to be invisible, for example, a movement like Via Campesina, which is not a new movement. It's been organizing around land for decades, but it's just become much more visible and much more prominent, and has contributed to international lawmaking and implementation for at least the last 2 decades much more robustly, through the Committee on World Food Security, for example, and through the contribution to the drafting of new legal instruments such as the Declaration on the Rights of Peasants, which passed the UN Human Rights Council, which has, by the way, huge implications for my mandate. Especially, I believe in my mandate, I will begin to look more systematically at rural housing, which has not been really a focus of the housing mandate in a systematic way so far. So lawmaking, and going with that, I think Sundhya was indicating perhaps an approach that emphasizes legal pluralism, in the sense of the rich lived pluralism, not the kind of formal legal pluralism that one has in mind. I believe that those kinds of practices should be celebrated and expanded over the years as a kind of a decolonial legal practice that can decolonize resistance. We also should celebrate more multiple modes of lawyering and exchange, not just, again, excessive focus on dispute resolution and tribunals, important as they are, but the critical role played by lawyers in movements. Movement lawyering, in what is called movement lawyering in law and society circles, is a critical role performed by many, many important lawyers. And we should really encourage that for our law students in particular, especially those of you who teach in law schools. I mean, I'm thinking of inspirational figures like Jacques Alphonse, who was a critical Brazilian lawyer, important in the FNRU and the RENAP movements, and Pradeep Prabhu, who was, without whom, the National Front for Tribal Self-Rule would not have taken place in India, and the important constitutional amendments that extended local self-governance to, indigenous local forested communities would not have happened in India. I'm thinking of people like that. I think, we need to sort of highlight and celebrate the role of movement lawyering much more as part of international legal practice. International legal practice is excessively focused on legal practice in the traditional conventional sense, focus on dispute resolution, for example. Thirdly, I would say, I think taking a cue from your approach to reparations, I think a reparative approach to human rights is a critical way to think about human rights in a more liberatory fashion, particularly economic, social, and cultural rights. Paying attention to history, the past, as you say in your report, but also the continuing legacy of the present. And I believe cases, some recent cases do offer some good examples of how that could be done. For example, I do think that the TAC campaign in African countries, but also a global movement that actually led formally to the Doha Declaration on Right to Health, which in turn sort of made a formal dent in the kind of the intellectual property umbrella that was being sort of cast all over the world through the TRIPS agreement. It's an important sort of milestone or an example of how social mobilization can ally itself with strategic considerations by states and can be done in a way which can actually, sort of try to not quite reform, but reorient international law, in this case, international trade law, as it happened. There are cases like the Awastingni case, for example, in the Inter-American Commission on Human Rights, which showed how, oral practices that, account for demarcation of indigenous lands could actually be elevated to legal standards. And then can in turn form the basis for recognizing tenure security for communities that actually lack them. I believe that there are similar models available for urban areas. For example, the recent work by Catherine Frank looking at community land trusts in the United States as a possible response to reparations is an important sort of intervention into the reparations debate that has relevance for my mandate for housing struggles. And then there are, finally, I would just note that I think we should also be bold in rethinking or redeploying conventional legal doctrines, maybe in private international law or others. For example, doctrines like unjust enrichment or abuse of rights. Why not? I've seen recently cases where involving Cambodian farmers suing corporations before UK courts, where the argument about unjust enrichment was used to actually score some significant gains. It's all an open field out there. And I do think that there are many ways in which one can use the tools that already exist on the books, but also push for new tools and new norms and new forms of plurality, like the Declaration on Peasant Rights has been trying to do. So I'll just stop.
Thank you very much, Raj. And I don't know if any of our panelists want to respond to anything that the panelists have said before I dive into some of the Q&A questions that we've been getting.
Can I make an observation, Tendai?
Please.
And picking up on what some of the questions in the Q&A, written Q&A are. So, Raj, I think you're absolutely right. I mean, one doctrine that springs to mind is the doctrine of odious debt as well as a very useful strategic possibility. But just in terms of what you said about studying and thinking about law and teaching law and the excessive focus on dispute resolution, I think one of the reasons why it's so important to think theoretically as well as practically is because of the very important theoretical observation that a liberal fantasy of international law is that international law is virtuous but marginal, right? It's a good thing that doesn't do good things because it's powerless. But actually, once you historicize it and think theoretically about it, what you see is that international law is what Gary Simpson has called powerful and constitutive. That is, that its power lies in its world-making function. So when we think of an institution like a state does not exist before law. States and laws come into being together, right? So when we think about some of the questions that have come up, which say, how do we address the question of economic inequality, or how do we deal with the disparity, the economic disparity between different states so that we can implement good international laws? My suggestion would be to say, think about the way that international law is not exogenous to that structural relation. It produces it. It's a regime that is produced in part through the operation of international law. So it's not that the world exists and then international law enters the world. It is that international law is fundamentally involved in producing the world that we have. So if you think of it like that, it doesn't become a question of, well, there are too many exogenous factors to allow us to do anything with international law. It becomes a question of, almost like the physician's credo, first do no harm. So first ask, what role is this international law, is this regime playing in the production of certain forms of relations, and then go from there. So even the question somebody asked about universal humanism and how do we critique humanism whilst holding on to its goals, my suggestion would be as a teacher to say, don't make the assumption that you want to hold on to its goals. Ask what work universal humanism is doing in structuring the world and then work from there. You can't save the virtuous part for international law and put the other stuff somewhere else. You have to have a much more theoretically astute and historically informed account of the work that international law institutions and doctrines are doing in the world.
Thank you, Sundhya. And you're a dream panelist who's, already answering the questions that are in the Q&A. So that's great. And I encourage other panelists to do that to the extent that they would like to. So I want to just respond. There's a few people in the Q&A who've said they would really appreciate the bibliographies. So Sundhya, we'll be following up with you to coordinate that. And I also want to highlight that there is an online platform, TWAIL, which is the TWAIL Law Review, which I think has really powerful resources along some of the themes that we've been discussing. So in the interim, while we put together that bibliography, which my colleague at UCLA, Asla Bali, and I will also contribute to, you can definitely check out the TWAIL website, which is useful in that way. So Sundhya already has gotten us started on some of the questions that are in the Q&A, and Raj and Makane, I want to give you an opportunity to respond to them. So there's two that I'll group together. One is basically saying thank you to all of you for your enlightening thoughts. I was wondering how we should situate the humanization of international law project in the context of the current discussion pertaining to decolonization of international law. Are they exclusive of each other, or can we say the former is a subset of the latter? So this is about the humanization of international law project. And then another question that might be related is one that asks, within post-colonial studies, there's a well-known suspicion of universal humanism. How do you or any of the panelists speak to the critique of universal humanism while preserving some of its most salient goals, such as extending rights more equitably? And so Sundhya's given us her views on those, but feel free to jump in, Raj and Makane, if you have any thoughts on that. If not, I'll move on to some of the other questions.
I think that Raj is surely better placed than me to speak about the humanization and universal humanism. But what I wanted maybe just to say from my perspective is, once again, what is the definition of humanization of international law? Of course, that I believe that this is part of the broader debate on decolonizing international law. If you take, for instance, the global child labor regime. The global child labor regime is a very interesting laboratory to discuss the connection between humanization of international law and the broader debate on decolonizing, because you have countries, mostly countries from the rich world, that consider that child labor should just be prohibited, period. You even have an IILA, International Labour Organization Convention 182, which is just about, prohibiting child labor, period. But then you have in many parts of the world, in the developing world, where, child labor is actually important for the sustainability, for the resilience of those societies. So the question is, how do we perceive also humanization? The very notion, very idea of humanization can be, subject to this all, debate on reconceptualizing in international law, because there has been one direction to what humanization means in the system. So that's what I would say, that I would say that it is part of the broader debate, but I would think that Raj is surely better placed than me to jump on these two questions.
I'll just add very briefly that I think, of course, I do agree with what Sundhya has said, and on this in terms of post-colonial response. I think the problem or the discomfort that that post-colonial scholars have had with the criticisms that have come about universal humanism have more to do with the word universal and less to do with the word humanism. Humanism is a very wide concept, and you could interpret it in many different ways. But if it emphasizes, for example, the idea, as Sundhya said, do no harm, it emphasizes a particular view of, preserving life as it is and valuing it for its own sake, which is a very different sort of thing from, or it's a different sort of issue from the idea of universal or universality that precedes the word humanism. Instead of the word universal, perhaps, as many TWAIL and many post-colonial scholars have been pushing, and certainly this is something that has been true in the post-development literature, we should probably try experimenting with the word pluriversal, in the sense in which it's not a perfect word, but it does go, I think it does a better job of capturing some of the sentiments that are being expressed and have been expressed in the past, in terms of, for example, valorization of multiple forms of living as being equal, not, for example, giving into that gap that Sundhya said that exists in the Australian policy, for example, regarding integration. There is no assimilationism if you don't actually assume that something is universal. If something is pluriversal, then multiple forms of living become equally valid. It doesn't mean that they cannot be criticized on their own terms for falling short of particular normative standards. But nevertheless, it actually starts from the premise of plurality. And I do think that certainly for human rights, this is something I've been arguing in my work in a number of different ways over the years. There has been a dire need to go beyond this idea of universality for years and years and years. We need to find another language. We need to find another practice. Is that all you wanted me to respond to? Okay, thank you.
No, I mean, feel free to respond to anything in the Q&A, Raj. Definitely do not feel constrained by the question I posed. Is there anything in the Q&A specifically that you want to speak to right now? And please do so. And if you're taking a look, I could consolidate two questions that have come in that it would be useful to hear from everyone else on. But again, I welcome you, all of you, just jumping in according to your interest. So there's two constituencies who are participating, and there's a number of different constituencies who are participating in the webinar, but two include practicing international lawyers and then students in law school, including some who are about to graduate. And there's two questions that come from each of those constituencies that are related. So one is a question about how international lawyers can contribute to change on a day-to-day basis to advance some of the insights that each of you have highlighted as priorities. And then a related question from somebody who is a graduating law student who's saying, what advice would you give to graduating law students who are interested in pursuing careers that might, bring to fruition again or advance some of the visions that you've articulated, including things like movement lawyering and the like. So I'll put that to all three of you, and then also welcome you to jump in on any of the questions that are in the chat right now. And for our audience members, please feel free to keep asking questions.
So if I can jump on the question on how international lawyers can contribute, Tendai, my personal experience, once again, in the field of investment negotiations, what I found out is that capacity building is very important. You cannot have in many parts of the developing world an agenda of decolonization or pushing for decolonial practices if the stakeholders or if the government people in particular to whom you are talking are not aware of the challenges and aware of why it's so important. And what we have found out, I've been doing capacity building in the field of investment law for the last 15 years, and what we have seen is that where in the countries where we have been going for years and years, talking to the people, explaining to the people the challenges and why some of the rules, why some of the instruments of international law are not relevant for us, there has been progress. There has been real progress. A country like Indonesia, for instance, now has adopted a moratorium on negotiating investment agreements. It's not that they woke up one day out of the blue and they did it. There has been work behind. The position of South Africa, there has been work behind. The position of the African Union regarding investment agreement, there has been work behind, and that work is called capacity building. So we should not underestimate as international lawyers, both from the academic side and from the practitioner side, we should not underestimate the power of knowledge, the power of capacity building in order to advance these decolonial purposes. But if I can use that little opportunity, Tendai, just to jump on what Prof Raja was saying, I don't think we should see movement lawyering and legal practitioners as being clinically isolated from each other. I believe that actually they should be mutually supportive. I am somebody who considers himself as legal practitioner, but I also consider myself as a movement lawyering. And I don't believe that these are, separated categories. We actually need to build the bridges. And this is what IILA is trying to do, building the bridges between, movement lawyering, legal practitioners. So this is also very important. If you want, as an international lawyer, to be able to have some impact, to have, policy makers listening to you in how they can actually change the rhetorics of international law, you need to have this double hatting. You need to have this double hatting. Otherwise, if it is just about movement lawyering, sometimes it might have some limits, in convincing some of those folks to follow what you are suggesting. I'm saying it from the perspective of somebody who I believe has the double hat.
Thanks so much, Makane. Raj or Sundhya?
I mean, on movement lawyering, I would just say, because it is one of the questions as well, I think that the challenges are actually far deeper than one realizes, because the issue actually arises with the very structure of legal education and pedagogy, the type of materials that we think are appropriate for studying as lawyers, the kind of legal training that is emphasized clinically in law schools, the kind of client engagements that we do, especially in much of the developing world, where even the kind of some of the clinical legal education approaches, for example, remain relatively weak, especially in countries like Indonesia, for example, that you refer to, Makane. And my challenge really, as an academic, what I have found is how do you actually get people to deprofessionalize themselves enough from what they are learning, while at the same time being technically, expert in what they're doing. And if you take yourself far too seriously and fall in yourself with your skills in that way, you are going to, chances are not very likely that you'll become a movement lawyer, whatever that is. And I do think that if this is to be a serious project, the law schools should, in particular, if we're talking about training of lawyers, should treat this as one of the central strategic objectives of legal education, rather than seeing it as something that you deal with because it looks nice on your brochure, it's a pro bono thing or whatever. So in terms of, there was one other question, maybe briefly I can say, on best practices from the South, how do they actually travel, and institutional resistance. Absolutely. There's always going to be institutional resistance to these kinds of practices. And participatory budgeting, since the question referred to South America, I could say that I've been sort of studying the role of participatory budgeting and teaching it in some of my courses. As we know, it came out of Brazil, but it was initially a very difficult idea to accept for many in Western cities. But the reality is that it has found quite a bit of traction in many American cities, for example, along with other sort of mechanisms or languages that have also emanated from Brazil, like the idea of the right to the city, for example. It used to be a Brazilian conversation, but now it's a global conversation. And I give full credit to the Brazilian civil society networks for making that happen. And just to clarify, by the way, these Brazilian civil society networks are typical of civil society networks in other countries. They are in the civil society when they are in the opposition, but when your side wins the election, they go and join the government. They become part of the state. So I think we should also, I agree there with Makane that there is no necessary sort of contradiction between movement lawyering and mainstream lawyering, if it means representing states, for example, or representing clients before formal dispute resolution bodies. This kind of revolving door constantly happens. People are in movements one moment, a few years down the road, they're in the government or they're actually litigating something else. This happens all the time. But they kind of the people who I know have done it, they've stumbled into it. They kind of accidentally found themselves doing it. I'm saying that's not good enough. We need to actually make this as a strategic priority of legal education for this to happen at scale, so that we have enough people doing it.
Thanks, Raj. Any final reflections, Sundhya?
I guess in terms of advice, there's no global prescription, because what you can do will depend on where you stand in all sorts of different respects. And so my best piece of advice to anyone in the participant list is read more, because you can't, there's a famous book that was published in Australia about the oppression of Aboriginal people called Why Weren't We Told?, written by a kind of white historian. And I always felt, well, if you're Black or if you're one of the oppressed or in any whatever axis, you don't have the luxury of waiting for someone to tell you. So my question is not why weren't we told, but why didn't we ask? And so I think that the first thing everybody in the participant list who wants to know what they should do can do is read more, because you need both technical mastery and theoretical and historical depth in order to understand what interventions might be effective, what strategic uptakes of doctrine might work, how you can assess the objectives, how you can teach in particular ways, all of those things starts with reading more. And so everything is dangerous. There's no position which is going to be protected by its virtue just because it's got the name of a traditionally progressive set of institutions. So that's my big piece of advice. But I am a teacher, so I would say that.
Thank you so much. So, we've come to the end of the time for the webinar. And before I thank everybody, I want to just let everyone know also that we do have the next webinar in the series coming up, and Mariam's going to put a slide up with information on that event, which will be focusing on decolonizing the future, the making of international law, and we'll have another wonderful array of speakers as well. I want to thank the co-sponsors, Gibson, Dunn, IILA, and also the TWAIL Seminar at UCLA Law. Thank you so much for making this possible. But thank you also to the panelists for your really rich and powerful interventions, and even more so for the lifetime of work that you've devoted to these issues. We spoke a fair amount about my reparations report, which would not have been possible without the kinds of insights that you all have committed your lives to making clear in the law. So thank you so much for joining us. And we hope that many of our audience members will come back again on January 13th for our next event. Thank you.